Thank you so much for joining us this morning. So I'm Kelley Stoppels. I am an attorney in Miller Johnson's Labor and Employment Group, and I'm joined today by my colleague and friend, Keith Eastland, who also is an attorney here with us at Miller Johnson in the Labor and Employment Group. Today, we're going to be continuing our Workplace Wednesday series. And for those of you who have been with us from the beginning when we started this about 6 weeks ago, you know that we have been focusing on traditional labor or union issues under the new Biden administration and things that we can expect to see moving forward in that arena. So today, our focus is going to be on where we expect the pendulum to swing with the new Biden administration. And no big surprise there. We expect to see a return to protections for employees as Biden establishes his new National Labor Relations Board. I know that we have an hour blocked off this morning for our webinar. I don't expect that we're going to take that entire hour. We should be able to get you out of here in about half an hour or so and then get you on with your day. So with that, let's go ahead and get moving forward. All right, so looking into our crystal ball, what do we see coming down the line? These are all predictions of what we see happening in the future, right? What do we see happening under the Biden administration? Well, the expectation that we all have is that there is going to be a pretty dramatic shift back to what we saw under the Obama administration. For the last few years under the Trump presidency, there were many pro-employer rules and decisions that we saw coming out of the National Labor Relations Board. The focus was really more on being business-friendly, company-friendly, and in our view, a move back to a bit more of a common sense approach toward just letting you manage your workplaces. The expectation moving forward under the Biden administration is that there's going to be a move away from that and a move back towards the policies that we saw under the Obama administration. So much more focus on being employee-friendly, union-friendly, perhaps less of a focus on the employer needing to manage their workplace and more of a focus on what the employee might like to see coming out of that administration. So that's what we see coming. Why do we see this? Obviously, whenever there is a change in which political party controls the White House, we're going to see a shift in policies, a shift in focus. And traditionally, what you would expect to see is that when there is a change from a Republican administration to a Democratic administration, there would be that shift towards more pro-union policies, towards more pro-employee protection policies. I think that we're going to be seeing that kind of on steroids under President Biden's administration. And here's why we think that, right? Just a reminder, this is the pledge that President Biden ran for office under. He said multiple times that he was going to be the most pro-union president you've ever seen. This is what he said in his pledge when he was running for office. He wanted to focus on holding companies accountable for violations of labor law. He was going to encourage and incentivize unionization and collective bargaining, and really focus in on how workers are treated in the workplace. He is very pro-union. I think President Biden is a true believer in unionizing the workforce. And we have seen him make good on this pledge just within his first couple months in office. He ran on this platform, and from day one, he has been issuing executive orders and making appointments that show that he is planning on carrying out this pledge. We also saw him weigh in publicly on the Protecting the Right to Organize Act. We've covered the ProAct in probably for some of you what you feel to be excruciating detail over our first several Workplace Wednesdays webinar. I would encourage you to take a look at our YouTube channel and pull up those webinars and see what all the fuss is about relating to the ProAct. President Biden is very much in favor of the ProAct, and he is in favor of encouraging unionization. There is no doubt where his head and his heart are on this issue. And as I said, we have seen him making good on that promise, that pledge, from day one. In January, his first day in office, he took a really unprecedented move related to the National Labor Relations Board General Counsel. Generally, General Counsel for these different agencies, they have a term they're appointed to. And what we have seen historically is that even when there is a change in administration, the General Counsel finishes out their term. So what we normally would have expected to see is that Peter Robb, who was appointed to the National Labor Relations Board as their General Counsel under former President Trump, that he would be permitted to finish out his term. And I believe he still had about 10 months left on his term. President Biden asked him to resign. Peter Robb refused. When he refused, Biden took the unprecedented action of terminating Peter Robb. So we have not seen this previously in the history of the National Labor Relations Board. This is really a strong step. It really is unprecedented action. And the reason why this is so important is because the General Counsel at the National Labor Relations Board, they have prosecutorial discretion. And what I mean by that is the General Counsel really sets the tone for where the NLRB is going to be focusing time and resources. They decide which actions they're going to prosecute. They set operational policies for the National Labor Relations Board. They set the tone for what the focus is going to be for that agency. It's a very important position. President Biden, after terminating Peter Robb and his second in command, then appointed Peter Orr as the agency's acting general counsel. And we have already seen the acting GC rolling back many of the Trump-era operational policies that were more favorable to employers. So this clearly gives you a good indication of how strongly President Biden feels about unionization and creating a more pro-employee, pro-union friendly National Labor Relations Board. And when we're talking about the National Labor Relations Board, a quick reminder there, the NLRB is essentially a panel of board members. The president has the right to appoint board members to a term. The composition of the board is very important because when the National Labor Relations Board weighs in and issues a decision, it's a majority rule. So this is why you see really major swings in interpretation of traditional labor or union laws when there's a change in administration. This is why we had that huge shift from the Obama-era policies to the more employer-friendly Trump-era policies. Right now, the composition of the National Labor Relations Board is that there are 3 Republican appointees, 1 Democrat appointee, and there's 1 position that's vacant. If you look at the timing of when those terms expire, we have Republican appointee Emanuel expiring this coming summer. So just a few short months out, there's going to be another position available for President Biden to fill. Between that and the vacant position, that means that very shortly we could see a Democrat majority on the National Labor Relations Board. And that's where we're really going to start seeing some action when it comes to decisions that are issued out of that National Labor Relations Board. So we have now a Democrat appointee, Peter Orr, as the acting general counsel, determining where the focus is going to be for prosecution, what the operational policies are going to look like. And then in a few months, we're going to have a Democrat majority National Labor Relations Board essentially kind of sitting as a judge on those decisions that come through and reach their desk. So there's going to be a shift, a big shift in terms of ideology and focus coming out of the National Labor Relations Board very soon. All right, so we've talked kind of about the background of the General Counsel and then the structure of the National Labor Relations Board. As you'll see as we move through the additional slides, what I would recommend is hold on tight. We are going to be seeing some pretty big changes coming through from the board. You know, I think this slide is perhaps a little bit misleading. I think perhaps some of the people that we can see on this pendulum swinging look like they're having more fun than maybe what we're in store for. But get ready, because there are going to be some shifts coming up. All right, so our predictions. I think that pretty much any area is open to a major shift once we have that Democrat majority in the board. But here are a handful of topics where we want to kind of focus your attention today. These are areas that we think are extremely likely to be revisited sooner rather than later. So we think that there are Trump-era policies in the areas of workplace policies and handbooks, employee discipline, email, more generally employer property, confidentiality rules, and the scope of a bargaining unit. We think that these are surefire bets for areas where we are going to see an abrupt change in policy, an abrupt change in what the legal framework is moving forward. So let's dive into that a little bit more. Workplace policies and handbook rules. You know, the current standard for workplace policies and handbook rules under Boeing, which is a case that came out in 2017, this is more, to me, a more common sense approach to taking a look at whether rules are lawful under the National Labor Relations Act. And as you know, when we're evaluating a policy, if it's neutral on its face, and there's a concern that the rule might interfere with the exercise of employees' rights that are protected under the National Labor Relations Act. So, for example, the right to work together to bring a group complaint to an employer, or work together to try to form a union, that kind of thing. There's an evaluation of two factors, right? So we're going to be taking a look, you know, what's the extent, what's the nature of a potential impact on NLRA rights. And then second, and I think this is really important, you as the employer, what is your justification or explanation for the rule? So, you know, what the employer's thinking, what the employer thinks that they need in their workplace, that comes into play under the current standard. And since the time that Boeing was decided, it's been very clear that the decision really was a big win for employers, and it's really a move towards a more common sense approach. One thing that I think has been significant, and I always use as an example here, is civility rules, right? Under the prior Obama administration policy, there were rules about being civil for employees in the workplace being civil to one another. Those would have been found to be a violation of the law. And to me, that just kind of doesn't make sense, right? it makes sense to me that you would expect employees to behave respectfully and civilly in the workplace. But under the prior policy, that would have been a violation. So the current policy, my view, is a much more common sense approach, and it takes into account you as the employer, your ability to have common sense rules and control in the workplace. Unfortunately, my expectation would be that under the new administration, there's going to be that pendulum swing back to what we saw under the Obama board. And previously, I'm sure many of you remember this rule because, quite frankly, it was confusing and very difficult to comply with or predict what the outcome would be for various work rules. And the prior standard was the Lutheran Heritage Standard. And under that standard, a rule is unlawful if it explicitly restricts Section 7 rights. Okay, I get that. Or if it doesn't explicitly restrict, but employees would reasonably construe the language to prohibit Section 7 rights, it was issued in response to union activity, or it's been applied to restrict the exercise of Section 7 rights. Now, the big one here for me, as I would try to work with clients through this issue, is that letter A, right? Reasonably construe the language to prohibit Section 7 rights. Now, let's be clear. When we're talking about a reasonable person, who are we talking about? We're talking about the National Labor Relations Board General Counsel. That's who we're talking about because that's the individual who gets to make the determination about whether or not a case is going to be prosecuted. We all saw the impact of this rule. Quite frankly, it was impossible to predict what might offend the sensibilities of the National Labor Relations Board, how far things would go in terms of, in my view, stretching rules to find that there's a way that it could reasonably impact someone so as to prohibit Section 7 rights. And, you know, in my view, there were a lot of legitimate neutral rules that, from my perspective, you know, common sense approach made complete sense in the workplace, like those civility rules, but they were found to be unlawful under this standard. There was a lot of uncertainty, a lot of unpredictability under this standard. And unfortunately, my bet would be that this is what we're going to be shifting back to under the Biden administration. All right, employee discipline. So the current standard and this case, this General Motors case that came out last summer, this is honestly one of my favorite cases under board law because it really hit the reset button. The current standard is that the National Labor Relations Board has recognized employers might have a legitimate non-discriminatory interest in disciplining or discharging employees for certain profane, abusive behavior, even if that behavior relates to Section 7 protected activity. So let me tell you a little about what happened in this case. There was an employee who was suspended because he was making really lewd and racially charged remarks towards management in a union-related meeting. So the employer said, hey, totally inappropriate. We can't have that kind of behavior in our workplace. We're going to suspend you. The administrative law judge, who is the initial individual who heard the case, he found that that activity was protected under the National Labor Relations Act. When it made its way up to the National Labor Relations Board, and again, that's that panel that we were talking about earlier, they determined that no, that behavior was not protected. And they reset the standard for determining whether employees have been lawfully disciplined or discharged after making abusive or offensive statements in the course of activity that might otherwise be protected. And there is great language that the National Labor Relations Board actually issued. Former Chairman John Ring actually stated that it was a long overdue change in the NLRB's approach to, quote, profanity-laced tirades and other abusive conduct in the workplace. He stated that the board for too long had protected employees who engaged in obscene, racist, or sexually harassing speech that just simply wouldn't be tolerated in any other workplace. And again, his view was that it ended that unwarranted protection and eliminated the conflict between the National Labor Relations Act and other anti-discrimination laws. This is a great decision. This gives you the power and some control in your workplace to discipline for behavior that is unacceptable, even if it occurs related to in the scope of Section 7 protected activity. So this is a great case and a big win for employers. Unfortunately, I don't think it's going to last. I think what we're going to see is that moving forward, there's a swing back to the earlier line of cases. And honestly, there's decades of precedent with the National Labor Relations Board protecting activity in the workplace that is quite simply unacceptable. But because it is linked to Section 7 activity, so activity that is protected under the Act, be it a grievance process, speaking up in a meeting, engaging in activity where you're perhaps trying to organize a union, that kind of thing. If it's related or occurs during that activity, the board had previously found it to be essentially protected. And the prior standard required evaluating a totality of the circumstances to determine whether or not the behavior was protected. Now, this did a couple things, right? It created a situation where there was a lot of uncertainty about where those lines were. And it also created a situation where employers were in a catch-22. If you disciplined for behavior that was egregious, inappropriate, really crossed the line, you were then risking potential legal action simply because of when the activity occurred. If you take a look at the prior standard, the NLRB said, hey, protections of Section 7, we need to take into account the realities of industrial life. Section 7 activity, it could become heated, it can engender strong feelings. So if there are statements or behavior that occurs during protected activity, it needs to be so violent or of such serious character as to render the employee unfit for further service. So essentially, the action needs to be so egregious that it therefore loses protection of the Act. So like I said, the employer is in this catch-22. You issue discipline, which you would for employees who engage in that behavior in any other setting. You risk potential legal challenge, or you let it go because you're worried about their Section 7 rights, and you're implicitly condoning inappropriate, completely unacceptable behavior. So what are we talking about when we're talking about egregious behavior? How far does that behavior, the statements, need to go to lose protection of the Act? Well, here are some examples. Under the prior standard, employees' activity remained protected even after referring to the owner of the business as a effing mother effer, an effing crook, and another inappropriate word. Employees' activity was still protected even though he called the company vice president a stupid effing moron. An employee was still protected even though he referred to his supervisor as an egotistical effer. And these are just a handful of examples of behavior that we would not tolerate in the workplace that was found to be protected. The other thing I would mention is that there has been a lot of conflict between expectations in the workplace related to making statements that are racially motivated or sexually explicit, that the expectation would be that we would discipline for and would have an obligation to discipline for. And this prior standard where it's gray as to whether or not that type of behavior loses protection of the Act. Unfortunately, as I said, I think it's very likely that we're going to be swinging back into those kind of murky waters moving forward related to employee discipline. All right, employer email. Current standard, and this is Caesars Entertainment 2019. You as the employer, you have the right to control use of your workplace equipment. And that includes your email, your IT systems. You just can't restrict employee use in a manner that discriminates against union or other protected concerted communications. It's your right to control your system. And again, to me, that's a common sense approach that makes perfect sense. The board, since the Caesars Entertainment decision, has also issued some really good law about what it means to discriminate against union or protected concerted communications. So there's board law currently supporting the idea that even if you allow employees to communicate about signing a condolence or a birthday card, or to communicate about, hey, there are free beverages or snacks in the break room, but you do not allow people to communicate about union activities, there's case law saying that that's okay to draw the line that way. So right now, there is some good authority for employers related to control and use of your email and IT systems. Unfortunately, my view would be that that is going to be going away moving forward. I'm sure all of you remember the prior standard on employer IT programs, employer email. The previous standard under the Purple Communications cases was that, no, we understand that's your system, but employees have the right to use that email system for union and other activities that are protected by federal law. So I know that when Purple Communications came out, that was a big shift in thinking for employers. And again, it, in my view, kind of defies common sense. It's your policy, but the standard was, well, employees have a right to use that policy for union activity. I think that it's likely that this is where we're going to swing back to moving forward under the Biden administration. And with that, I'm going to turn it over to my colleague, Keith, to walk you through some other areas where we expect changes moving forward.
Great, thanks, Kelley. So what we just went through was sort of the microcosm for this week, right? 2 awesome sunny days and now a rainy Wednesday morning, right? Let the rain begin here. No, seriously, Kelley talked about how the NLRB is going to take away your ability to implement reasonable policies without violating the National Labor Relations Act, to apply those reasonable policies to protect legitimate employer interest. That's going away. She talked about how the NLRB's shift in case law is going to limit your right to discipline people for absolutely intolerable conduct. It's going to happen. And I would even venture to say it's going to be maybe worse than it was before if the promises that the current administration has made will be fulfilled to organized labor. Kelley also talked to you about how your intellectual or IT property is not going to be yours anymore if employees want to use it for union organizing. We're going back to Purple Communications. Well, I'm going to go next into your actual property, your physical property rights, right? We saw some great decisions from the Trump board with respect to your right to exclude union organizers or non-company employees, outside agents. And a particular note was this Kroger decision came down in 2019. And it's a fantastic case because it highlights how much more reasonable the board has been in terms of protecting employer physical property. This case involved a union that wanted to go onto the supermarket premises with signs to boycott Kroger and tell the customers, hey, don't buy Kroger's products. Don't shop at these stores. We have a dispute about transferring employees, et cetera, and you shouldn't shop here. Boycott Kroger. And the judge said, well, you can't exclude those people because you allowed things like, Salvation Army drives. We all see it when we go into the grocery store, in the holiday season. Well, because you allowed that, you have to allow union folks, even if they're boycotting, right? They're advocating a boycott of your stores. And the NLRB said, no, stop the madness. What is discrimination? Discrimination really is when I take action based on union activity or protected concerted activity under the Act. And so what's critical here from this case is you get to look at the purpose, right? Just because something's similar in conduct or nature doesn't mean it's similar in purpose, right? So if you're soliciting for charitable organizations, United Way, et cetera, that's not the same thing as allowing somebody to solicit to attack your business. It's absolutely eminently reasonable for most of us, I think. But they said it in a written decision, and this was a tremendous win for employers, and recently upheld, by the way, by the D.C. Circuit. A similar great case that came out, and this came out during the pandemic here, and Kelley mentioned this a little bit earlier when she's talking about solicitation, is the idea that, hey, look, it's perfectly lawful to allow your employees to use communication devices, message boards, emails for things that are going to improve employee morale. And we don't think the union message or union organizing is going to improve employee morale. We have a right to do that. That's not discrimination, right? You've probably heard us say it a million times, or if you've ever gone through this, like, well, if you're going to allow some outside solicitation, you're opening that up potentially for the union solicitation. That was the old previous standard. But take a look at what this T-Mobile case, what the NLRB said you could do. In that case, the employer allowed employees to use email to circulate things or messages such as free popcorn, hockey tickets, nacho day in the cafeteria, salsa and lip syncing contests. I don't think I would do either. Deaths in employee families, condolence cards, baby showers, birth announcements. So the idea was, hey, look, we got to recognize that people want to feel good about the place they work in. They want to be able to communicate with their coworkers, and they want to connect, and it's good for employee engagement and morale, right, to allow these things. And so why would we punish an employer who does these things and permits these things by saying now once you open that up to something that might help improve the workforce, the workplace environment, now you then give up your right to exclude union messages? It just didn't make a whole lot of sense, and this is a great decision. But now we're going back, guys. We're going to go back to that standard where if you start allowing civic, charitable, or promotional activities, even if they're similar in nature, the NLRB is going to throw out the purpose. And they're going to say, well, you're discriminating against the union if you don't allow their messages. So all these great gains are going to be lost in a matter of months, right? Kelley pointed out on the slide earlier, there's going to be 2 vacancies filled probably around August, September, October, once the Senate confirms the new board appointments. So more great news, right? Okay. Here's another, and by the way, what we've tried to do in these slides is kind of highlight the general big things we think are going to change in case law. There's a million of these. We could probably talk for 2 hours on this if we wanted to, but we're just trying to highlight the key things we think impact the most employers. Another is confidentiality policies and rules, right? Most of you have a rule in place that says when we're investigating EEO complaints, et cetera, workplace investigations, potential discipline for theft, whatever it may be, a lot of employers tell their folks, we need you to keep this confidential to the extent possible because we need to protect the integrity of the investigation. We don't want witnesses to be retaliated against. They need to have the trust in the HR professionals that this is going to only be shared to the extent absolutely necessary, okay? And what the board said in the 2019 case, Apogee Retail, was, hey, look, if you want to have that rule of confidentiality, as long as that rule is, tied to the duration of the ongoing investigation, that is absolutely 100% lawful on its face, even though it might restrict employees' abilities to talk about their workplace terms or conditions, which would be Section 7 protected activity. That's their right. We all know that, right? They can talk about their wages, talk about their terms and conditions. But the board said, no, under that Boeing, those categories of rules and policies, this is a category 1, which is absolutely lawful on its face. We don't have to balance these interests because it's just so obvious, right? And what I loved about Apogee was it said this, and the GM case said this too, Kelley referenced before, is look, employers are put under conflicting directives and guidance from different federal agencies, right? The EEOC has regulations and guidance that says you should keep this stuff confidential. We need you to keep it. We want you to keep it confidential to protect employee rights. So when they come forward with claims of sexual harassment or race discrimination or mistreatment based on gender, whatever it may be, we don't want that gossiped all around. Well, that's the EEOC, but then you have the NLRB saying, well, that's unlawful because you're restricting, right, the reasonable person that Kelley talked about, right? We don't know how unreasonable that person's going to be. Well, it might technically, I think that might restrict my ability to talk about my Section 7 rights. Oh, that's unlawful. But that's where we're headed, right? This is going to be overturned. It's just a matter of time. And, as a labor lawyer, you learn this pendulum shifts back and forth, back and forth. And if you want to see where it's going, just read the dissents in all of these cases. Okay. Previous standard here, where we're headed back to on confidentiality rules, if they go back to this shortly, will be it's no longer presumptively lawful to require or direct employees to have confidential, not share the information about the investigation. If you want to take that position, if you're going to have that policy, you must apply it on a case-by-case basis, and your policy would need to reflect this as the law changes, and you're going to have to prove to specific facts and evidence as to why you believe confidentiality is required to protect the integrity of your investigation. Right? You're going to have the burden of proof as the employer. You're going to have to show that the employee actually came to you and said, hey, I'm worried about someone threatening me. I'm worried about violence. I'm worried about being retaliated against. You're going to have to document all that. Otherwise, you're going to risk violating the law. Right? And we all know how silly that is and how much extra work that's going to put on HR personnel. Every time you have a workplace investigation, now you got to go through this additional analysis. It sure makes a lot more common sense to have a blanket rule that says, look, during the investigation, everybody keeps this quiet. That's not going to be the case. You're going to have more work, or you're going to risk violating Section 8A1 of the Act. Okay. Another big area that's going to change, and you've heard us talk about this, I'm sure, before, if you've been to Miller-Johnson webinars or presentations, and that is the micro units, right? What group can a union organize within your organization, right? If you've got a manufacturing plant, can they pick and choose one, like the shipping department, right? If you have whatever it is, you have construction trades, can they just do, the apprentices? These sort of micro units. The idea is the union can then organize a smaller group because it needs less people to vote for it and to sign cards, and then sort of the camel's nose under the tent, right? And employers would say, well, wait a second, you can't just organize this small group because they have a community of interest, right? The same supervisors. These are our the interchange of job functions, interchange of employees, all these sorts of standard traditional community of interests that would get looked at. The board under President Obama said, no, we're going away from that. It's going to be the employer's burden to show that there's an overwhelming community of interest. Otherwise, we're going to let the unions pick and choose these little groups. We're going to let them bargain that way. Well, the current standard, PCC structurals in 17 said, no, we're rejecting that. We're going back to this traditional model. It's worked for decades. We're going to have it. We're going back to specialty healthcare. We're going back to micro units. It's just a matter of time. So what does that mean for you all? You need to think about your groups within your organizations. If you're a non-union employee and you want to stay union free and that's important to your organization, you got to start looking at the pockets, because unions are going to start targeting them again, and they're going to feel pretty good about their ability. And legally, we're going to take some L's here, right? Employers are going to take some losses if they try to expand the group that the union is trying to organize, because we're going to then have that burden of showing an overwhelming community of interest with all the other, if it's a manufacturing plant, it'd be the entire plant versus, some small department or some maintenance or whatever it may be. So that is on the horizon, and we'll be back. We did want to include a few points for unionized employers. I know some looked at the list, and some of you already have unions and you have collective bargaining agreements. And you're aware, likely, that the Trump board has made some very favorable rulings for you. And what does it mean? What are some of the things that are going to change for the unionized employer? Okay. Well, the first and most important one is the decision in MV Transport's going to be reversed. Okay. MV Transport was the case that said, look, if you have a contractual right to make reasonable work rules, it's not a violation of the act to enact a tobacco policy. That's a reasonable work rule. We're going to have a plain, ordinary interpretation of the contract that the union agreed to, and it's not going to be a violation of the act. Seems eminently reasonable, right? MV Transport overruled the clear and unmistakable waiver standard. And let me go back to that example I just mentioned. That's the classic example I like to use in highlighting this principle. So if you had a contract that said, we get to make reasonable work rules, and you then made a reasonable work rule that you had no smoking or no tobacco use on your facilities. There's a case, it's called High Tech, from the board under this clear and unmistakable waiver standard that says you have to bargain about the tobacco rule with the union because your contract language didn't address tobacco rules, and therefore the union didn't waive its statutory right to bargain with you over a tobacco policy. In other words, your reasonable work rule provision that everyone has ever relied on is actually worthless when it comes to the duty to bargain, because none of us are going to list out every single policy that we might attempt to negotiate or implement, I should say, during the term of a collective bargaining agreement. Right? This now puts another arrow back in the quiver of the union in the relationship with you. Now, if you got a good relationship, maybe they don't care. They're going to honor their contractual obligations. So, yeah, that's a reasonable rule. Fine. But if they want to attack you, file charges, they're going to be able to do that, and they're going to be able to stop you under this clear and unmistakable standard from implementing things during the term of a contract, even though you have the contractual right to, based on filing a charge. So if they want to dig in their heels, this is going to give them the ability to do that because we're headed back to the clear and unmistakable waiver standard. Second, expansive review of employer duty to respond to RFIs, right? And here, what we're going to see, I think, is union asks for information, we give them what's relevant, and then they're going to say, well, we want more. And we're going to say, well, it's not relevant. We gave you everything that's related to the terms or conditions of our employees' working conditions right now, their wages, whatever. And where we're going to see this is in collective bargaining when employers say, hey, we need to make changes because we're at a competitive disadvantage, right? It's long been the law. If an employer says, I don't want to pay $5 an hour, I don't want to give you the Cadillac health care because it doesn't make business sense, doesn't make economic sense. If the union asks to see your financial books as a unionized employer, you haven't pled poverty, they don't get it. If you say now, well, we want to make this change because of a competitive disadvantage, there's case law that's going to get this codified going forward. Not codified, it's the wrong word, but resumed or come back to being that says if you put at issue your competitive advantage or disadvantage vis-a-vis your competitors, you may be opening up a lot more of your financial books to the union. So you're going to have to be very careful what you say in collective bargaining. And things like what do supervisors make, what do non-union employees make, what bonuses do they get? That stuff's not presumptively relevant. I think the case law is going to shift where you may end seeing more and more employers being required to provide that information. Bannering and Scabby the Rat, bannering, picketing, these types of things that would be secondary boycott issues and that are not aimed at the primary employer with the labor dispute are going to receive additional protections. You're going to see ramped up union activity, I predict, on that front, and there's going to be much less you can do about it. And then I want to talk just a little bit about some of the elimination of the restriction on your employer's economic weapon. So if you're in collective bargaining and you're trying to get, use your leverage to get a new contract, some things that you could do right now is, well, if the contract's expired, we can tell the union we're not going to collect your dues. That's real leverage, right? And if the union wants to keep their revenue and their dues flowing for 300 people, or whatever is at your plant, 100 people, whatever it is at your facility, there's real incentive if you yank that stream of money. Talk about getting them to come to the table and get reasonable on a deal. That's going to go away. We're going to go back to the rule that says you got to maintain that dues checkoff and you got to continue giving the union money even when they're fighting you at the bargaining table and even if they're striking you unless and until you reach impasse, which is, if you're a unionized employer, you likely know that's difficult. Lockouts, there's a line of cases from way back that said employers can't lock out unless it's in response to a strike. That hasn't been the law for probably 50 years. My guess is it's going to be the law under a Biden administration and a Biden board. Use of permanent replacements. That's another area that's, hey, if you guys want to go on strike, union, we get to tell your people that we can hire people as permanent replacements. And if you guys come back from strike, if it's an economic strike, that is, you guys want more wages, whatever it is you want, you can strike for that. We can hire a permanent replacement. If we do that, that means all of your striking workers, when they come back, they're not fired, but they get in line. They don't get their jobs back until those permanent replacements decide to leave or get fired, et cetera. And that's a real position of leverage if you get into a fight with the union following expiration of your CBA. And you're also going to have to bargain every single discharge following contract expiration. Right now, the law is pretty decent on that if you continue to follow your policy, you're fine. So they can really bog you down and hurt your ability to take routine disciplinary action after CBA expiration. All right, I want to wrap up by coming full circle on the ProAct, right? Kelley talked about it. Why does it matter? All of the things we talked about this morning, right? Whether or not you have an overbroad confidentiality policy, whether you have a civility rule that's going to violate the act, whether you discipline somebody for calling their supervisor an MFer, right? All of these things now additional increased risk of violating the act once the law changes. Okay, well, why does the ProAct matter so much? Well, look at this. Every single one of those violations is now potentially a fine up to $50,000 if this act passes, if the ProAct becomes law in its current form. Okay, not to mention you're going to have daily penalties if you're found to have violated the act and you don't comply. You have additional penalties. We did a whole entire webinar on these penalties. I encourage you to check that out if you're interested. But the bottom line is it's going to have real teeth. I like to call it vampire fangs right now. Maybe the final version will be scaled back a little bit of whatever gets passed, but there's going to be teeth. There's going to be fines and all of these things that we're like, okay, yeah, this seems ridiculous. We're going to have the right policy for our handbook because it's right for our organization on confidentiality, for instance, and it complies with the EEO guidance. Well, now you may be risking significant legal fines for every one of those, right? And second bullet point, what do you think unions are going to do? They're going to get a hold of your employee handbook. They're going to find out what's going on. And every time your supervisor violates the act or every policy that they believe would significantly interfere with that reasonable employee, that could potentially be an 8A1. So think of all the policies you have. I go back to, and maybe some of you remember this, but there was some discussion under the Obama board that an at-will disclaimer in your employee handbook would be a violation of the National Labor Relations Act because it would suggest to a reasonable employee that you would never have a contract with the union. That's nonsense, but that was legitimate theory being advanced. If that's where we're headed, which we really are, those are all going to be 8A1 violations. So think about that as a union organizing tactic, right? And I think that's going to present some very difficult decisions for your organization, which is, what do we do with our handbook if the ProAct passes? Do we NLRB proof it or not? And what level of risk are we going to tolerate? And you say, well, Keith, what about the filibuster? The ProAct may not become the law. Well, we've got some fancy AI tools here at Miller Johnson that we have access to, and we've put it through those AI, and the likelihood of chance of success for the ProAct actually being put in place as the law is 41%. That's not a small percentage. And so I think I'll finish up by asking the questions. Is your organization ready? What steps have you taken to prepare? How are you going to manage these new additional risks? And I think, HR professionals, leadership, by thinking about that now, before the ProAct becomes law in 4 weeks or 5 weeks or whatever it is, you can really be ahead of the game. And I think that's important. So I think that's all I have. Next slide, please. That's it. Unless there are any questions, we'll hang here for a minute. Otherwise, thank you for your attention this morning, and we appreciate you being with us.
And Keith, I'm not seeing any questions in our queue.
Okay, well, fantastic. Everyone have a wonderful day.
Thank you so much, everyone.